The push to have the post-election violence case taken up by the International Criminal Court was in the hopes of securing justice for not just the 1,300 Kenyans who died in the mayhem, but thousands others who were affected. Part of that justice was expected to include reparations. But with the last Kenyan case terminated, the hopes of getting any assistance now appear a distant dream, a dream which some of those in the defense say was sold to the victims without presenting all the facts.
For future cases, it's important not to deceive victims in Kenya and anywhere else. International criminal justice is not a lottery. It's not a money-making business. It's not to be embarked upon in the hope of getting a windfall of cash. What seems to have taken place is a false expectation that victims can get reparations. Justice must be viewed separately from reparations.
The Trust Fund for Victims that I spoke about has two mandates. One is a reparations mandate, and the other one is an assistance mandate. Both of them would translate into some form of assistance.
The Trust Fund for the Victims of the International Criminal Court only offers redress to victims after a conviction. But even without a conviction and with no doubt that there was violence, Judge Ebo Osuji in his ruling said the termination of the trial should not obstruct the prospect of the victims' entitlement to reparations as a matter of obligation of the government, or at the barest minimum as a matter of grace from the international community. Soon after the ruling, Attorney General Githu Muigai announced the impending launch of the International Criminal Division of the High Court that will provide an avenue for victims of the post-election violence to seek justice. During his 2015 State of the Nation address, President Uhuru Kenyatta announced a 10 billion shilling fund to provide restorative justice for the victims, a fund which to date has yet to be activated. Esther Kahombe Makori, Citizen Business Center.